Good morning.
Good morning.
May it please the court, I'm Gary Veazey. I'm here for Mark Welch, and I'd like to reserve 3 minutes of rebuttal time.
All right, sir, you may proceed.
We're here this morning asking the court to review and reverse this criminal contempt that was heard earlier this year in Chancery Court in Shelby County. Now, Mrs. Welch has filed multiple petitions for criminal contempt, which of course has an extremely high burden of proof associated with the conviction. You have the constitutional rights of presumption of innocence. You have the right to not to incriminate yourself or to exercise your Fifth Amendment rights. And you have the right for proof beyond a reasonable doubt. We believe that there is a failure of proof in the elements necessary to prove these many charges arising from these multiple petitions for criminal contempt. They center around the requirements of alcohol monitoring. Mr. Welch was required by the first judge, we've had 3 now, the first judge to take SoberLink monitoring test 3 times a day, and also to take various drug tests, which were duplicate tests, but they were urine analysis and hair analysis, and what's known as a PEth test, to determine what we all knew was true, that Mr. Welch was a man that consumed alcohol. But we know that they brought these petitions, and there's certain things that they must prove beyond a reasonable doubt. They must prove that there is an order of the court. Well, that's not very difficult. There was orders of the court, multiple orders of the court, that affected these type of testings and the orders that were given to Mr. Welch. They used the records of the business records of the SoberLink entity, which tells you, did you take the test, and if so, what time did you take it, and did you miss a test? They use those business records. They use the business records of the drug testing facility. Again, their business records that came in. So there was a violation of an order that certain tests were missed. Certain tests were missed. But the third and most important requirement of this criminal contempt was the willfulness. Was this action of Mr. Welch a willful act, an act for a bad purpose? We think there is nothing in the record. There's nothing in the record that establishes that. And that is the third element that they, the plaintiff, must prove beyond a reasonable doubt. To illustrate that, I go to the end of the hearing, the transcript from February 15th, where the chancellor on page 210 of the transcript, beginning at line 17, says, no negative interests flow from Mr. Welch's decision not to testify. And I didn't hear any proof on willfulness. I mean, I heard Sioka and Huff, and neither of them said anything on willfulness. Now that illustrates 2 points. One, there is no proof on willfulness in the record. 2, that this chancellor doesn't appropriately understand the burden of proof and the rule of law. Dr. Sioka, John Sioka, and George Huff were defendant witnesses. So what he's telling us in that matter is that the defendant didn't prove his lack of willfulness or willfulness. That is not his burden. That is the plaintiff's burden. So the court is operating under an error in his mind of what the law is. And he recognizes there's that failure of proof as to willfulness. The essential, if not the essential, one of the essential elements to prove that case beyond a reasonable doubt. To illustrate further that the chancellor was mistaken as to the law in this case, I go back to when it began, the transcript of January 28, 2022, on page 5, beginning on line 21. So we're preliminarily talking about moving forward. And the chancellor goes, okay, help me understand why the lack of any response is not by itself a reason to grant the petition. Now, Mr. Welch and his counsel chose not to admit or deny the allegations contained in the petition, but to remain within his constitutional rights, remain silent, and make the plaintiff or the prosecuting entities prove their case. But yet we're having to tell the chancellor that Mr. Welch has a constitutional right to remain silent. He has a constitutional right at that moment to be presumed innocent. But yet this chancellor seems to be saying, why isn't he guilty already? Because he hasn't answered.
Well, but in the court's written order, the court does find that the husband did willfully and knowingly violate the orders of the court. So at least at that stage, when he got to the order, he seemed to appreciate that that was an element of the crime here. And then on appeal, now we've got a presumption of guilt, correct? Because there was conviction? I mean, it's your responsibility to overcome that. What evidence would you point to in this record to overcome that presumption?
Well, I point to the lack of evidence in the record at all on the issue of willfulness. As you look at the appellee's brief, I mean, I don't know that there is a better example of that than their failure to cite to the record of any particular fact. Now, the chancellor has other obligations too, and he has Rule 5201 to comply with. And if there's a finding of fact and conclusion of law in that order, it's a very thin finding of fact. But there's no record anywhere that tells us what that proof on willfulness is. But I cannot prove what bad purpose Mr. Welch did not take these tests for. We have proof in the record.
Let me stop you and ask a question or two. As far as your position that there's lack of willfulness, let's back up. Is there any question that a valid order was down?
I'm sorry, any question?
Is there any question that a valid order was in place?
You know, there was an order in place. I disagree that there was
For purposes of appeal.
a understandable order. When we brief that in our briefs that I'm sure you've looked at.
What did your client testify he didn't understand?
Our client did not testify.
Okay.
But the facts in the records are that in our June 16th hearing, the court looked directly at Mr. Welch as he was being excused and told him that he did not have to take the 9 p.m. test, and then he's leaving.
Yeah, but we're going to work off the written orders here. We're not going to go back and hold your client to the standard of saying you didn't comply with the written orders plus whatever was the oral ruling was. I mean, we're going to just hold him to the standard of what we can find in the written order and whether or not that's clear or not. To me, pointing to the transcript and how the chancellor describes what's in the order really is neither here nor there. I mean, we're working off the written order alone.
You're working off a written order, and you have to acknowledge that it has to be an unambiguous order.
Where is the ambiguity in this order?
Well, The ambiguity is this, and I go back to it again because what the judge, so I've gone from circuit court judge initially in these initial hearings, then I was transferred to Chancery Court. So the judge in the initial hearing tells Mr. Welch he does not have to take it. Now, the order doesn't take the 9 o'clock test. I'm sorry. Let me finish that thought. Take the 9 p.m. test. Then he's excused. But the order does not say that, other than she attaches the entire transcript to the order and incorporates that transcript by reference. So in essence, she is having the written order say one thing, but by attaching the transcript, that language that I'm discussing at the present time is incorporated and becomes part of that order as well. So those two elements don't fit together. And what we're talking about is what Mr. Welch understood. And when he's directed by the court, and over 70% of the missed SoberLink test are the 9 p.m. test. So the vast majority are this 9 p.m. test.
We're talking about 142 tests, right?
There are 142 counts, but there are much more than 142 testing procedures.
But the 142 counts that the court found that your client did not take.
That is correct.
Okay.
And there are part of those SoberLink tests, part of the other testing, the PEth testing and the drug testing. Yes, sir. That's true. So what we're saying.
Was the position taken in the trial court that the order was ambiguous?
It was.
And what was the proof about that?
The language, I cross-examined their witness, their only witness, which was Mrs. Welch, on the actual language that I'm addressing today, that it says one thing here, and then Ms. Rogers asked some questions after Mr. Welch is leaving or left that changes to what is written in the order. So you have this series of confusion. Whether the chancellor agreed with me that it was ambiguous, I will say that he did not, but I think the record supports that.
Okay, thank you.
Thank you.
Morning.
Good morning.
My name is Laura Rogers. I'm with the Memphis Bar, and I represent Lisa Welch in this matter.
Will you be the only person arguing?
Yes, sir, I will.
Okay, you may proceed.
There were initially 190 counts of contempt that were alleged against Mr. Welch, and I think those numbers, the fact that they are as high as they are, is a relevant factor and a relevant factor that the trial court considered. This isn't a case when you look at the level of proof that is required to establish willfulness or to prove that the violation was established beyond a reasonable doubt. Each case is different, and in a case where you have one violation and only one violation, you may have a standard, the proof that may be required for that one violation may look different than the proof that is required in a case where you have someone who's violating the orders the way that Mr. Welch was. I think it's also relevant and was a factor considered by the trial court that you had 3 separate petitions that were filed. This wasn't a situation where Mr. Welch violated the court's order 190 times and then was surprised with one big petition. There were a series of petitions that were filed that clearly put him on notice that this was a problem. The first petition filed established the violations during a set period of time. And when Mr. Welch continued to violate the court order, there was a second petition that was filed in the series that addressed a second period of time. And then there was a third petition filed that addressed that third period of time.
And when I'm looking at the court's final order of contempt, criminal contempt here, I really have to go back and look at each of those petitions to discern which test Mr. Welch missed here, correct? I mean, because the court just sort of lumps them all together. Says from the beginning, from the remaining 175 counts of criminal contempt alleged by wife. So I have to cross-reference each petition to figure out what time period I'm covering here, correct?
In the order, the court did ask us to put together the totals so that we could deal with totals in the order. And so, yes, you do have to go back, and there was a exhibit that we submitted because we worked together to come up with those totals, and the totals are all that is referenced in the order. How many related to the SoberLink testing, how many related to the PEth, and how many related to the drug and the urine testing. And then
And it's only the SoberLink testing, that's the one where the vast majority is the 9 PM?
there were about 120, I believe, counts that related to the SoberLink testing. It wasn't all 9 PM.
Okay.
I think that's a false premise that we're working with. It was not just the 9 PM test.
Some of them were the 3 and 9
Some of them were
a.m.
the 9 AM, some were the 3 PM. There were days when Mr. Welch missed entire days, and I think that's also a factor considered by the trial court that shows in the record that when we filed our first petition alleged that Mr. Welch had skipped an entire day. When we filed our second petition, approximately a month later, he had skipped 3 whole days. And then when we filed our third petition, approximately 30 days later, he had skipped 8 whole days. So this was an individual who showed absolute contempt for the court's order and made a point of showing that in his conduct.
And the SoberLink records here are part of the record?
Yes, sir. Those were authenticated and we produced those. And the SoberLink records showed the time that he took the test, whether it was positive or negative, to what level. And one of the 5 counts that I want to talk about today, because those were the counts that the court found most serious, were the 5 that related to the minor children. And those were the 5 from which Mr. Welch was sentenced to jail for 50 days, 20 days of which were suspended. One of those, which was identified in the SoberLink records, one of those 5 counts related to Mr. Welch asking his middle son to take the SoberLink test for him. And the authenticated SoberLink records that were introduced at trial showed a picture of the son taking the test and indicated that the test had been rejected because of an identity error. It was not Mr. Welch. And as a result of that, that was one of the tests that Mr. Welch was ordered to take, a 9 PM test. He had to have 3 tests a day. And he asked his middle child to take the test for him, who was a minor at the time, living with him. And so that was one of the 10 days of jail that Mr. Welch was ordered to serve. One of the other 5 counts that were determined to be most serious was that Mr. Welch remained under an order not to have alcohol in his system when he was around the minor children. He was also under an order to SoberLink prior to having any contact to determine whether or not he should have the contact. He had to test before he could have parenting time. Mr. Welch, in his contempt for these orders, decided that what he would do is show up at a football game and spend time with the youngest child without taking a SoberLink test. The wife testified that she was there, that she had obviously driven the child there. The child was not able to drive himself there. She was there and observed Mr. Welch with the child, and that he had not SoberLink tested, and there was no evidence of a SoberLink test in the SoberLink records. That count also warranted 10 days in jail. The 3 remaining counts from the 5 that the court determined were most serious involved the oldest child, the oldest minor, let me say. There's 3 children, and in this case, the only children that were minors at the time that the case was filed was the middle child and the youngest. The middle child was a senior in high school, and at this time, that child lived at home with a mother, and the court had found that the child should stay with the mother. And the father was not to, Mr. Welch was not to go to the home, was not to be around the children unless he complied with these SoberLink requirements. What Mr. Welch did, however, was he moved that child, the senior in high school, into the home with him in violation of the court's rulings. And while he had that child living in the home with him, he tested positive for alcohol on 3 separate occasions that we cited to in our petition, just those 3. And the court also determined that because that was a violation of the court order that impacted the well-being of the children, it should be taken more seriously. And those 3 counts also were 10 days each, 20 of which were suspended from that 3-count finding. As for the proof and the willfulness, Mrs. Welch testified and was the only witness in addition to the records that we had from Mid-South Drug Testing and SoberLink. Mrs. Welch testified that she knew Mr. Welch had the ability. I mean, the entry of the order itself compelling Mr. Welch to do these things is evidence that he had the ability to do it, that he had a cell phone, that he was capable of getting a SoberLink account, that he had the ability to take the tests at 9 a.m., 3 p.m., and 9 p.m. And that's the element I think that Mr. Welch sort of skips over. He wants to go right to, well, how is it that this court's going to make me do this? And skip over the initial examination, which is there was an order that was entered. There was an order that was entered, and it was found by the trial court that he had the ability to do these things, that he had the ability at 9 a.m., at 3 p.m., and 9 p.m. to take SoberLink tests, that he had the ability every 3 weeks to take a PEth test, and that he had the ability on the 7th day of each month to submit for certain drug tests. As I mentioned earlier,
He had taken some of these tests, correct?
he had taken some of all of them. He just couldn't show up for all the ones he was required to.
So there's no lack of knowledge of the requirement that these tests be taken.
No lack of knowledge. And in some instances, for example, I think of the 142, I believe it's 12 were related solely to the PEth and the drug testing. There were instances in the records that were submitted where Mr. Welch would show up for a urine test but refused to take the hair test. So he was there, and there's no ambiguity on what he was required to do. The court spelled it out for him. You are to show up on the 7th day of each month, and you are to take a hair and a urine test. And the court even spelled out where he was to go. You are to go to Mid-South Drug Testing. There's no ambiguity on what he was required to do. There was no ambiguity with the PEth testing, which he would just skip randomly, just skip these tests. Again, show up every 3 weeks at Mid-South Drug Testing to take this PEth test. With the SoberLink testing, there was an argument made and cross-examination of Mrs. Welch regarding the 9 p.m. requirement. Now, Mr. Welch, as I said earlier, there were approximately 190 charges that we alleged against him in these 3 petitions. About 30 plus were dismissed by the court because Mr. Welch had tested, but he just had not tested on time. So all of the late testing was thrown out by the trial court. The only things that the trial court held him in contempt for, this 142 times, were times when he just absolutely missed it, did not test at all. So these 9 p.m. tests, as opposing counsel was referring to and referencing in the transcript, the ambiguity that they allege that Mr. Welch had, that his confusion that he had about whether he was to test at 9 p.m. When you look in the record, you see that that cross-examination was not determined to be a credible impeachment of my client's testimony. Mr. Welch was at the hearing, and he was present when the court ordered him to test at 9 p.m. There was an order in place that required him to test at 9 p.m. He was present. He heard the court's ruling. He heard my questions. He was there for the entire explanation by the trial court about what he was required to do. And when you'll see in the transcript that they are referencing, that I followed up with the trial court and said, okay, let me understand. He's to test at 9 p.m. Yes, he's to test at 9 p.m. Mr. Welch was there and present for that. If there was any confusion on Mr. Welch's part about what he was required to do, certainly at the time that the order was entered, And it was obvious in that order, and very clear in the order, that he had an obligation to continue to test and continue to test until 9 p.m. That would have alleviated any confusion that he had. The order itself, the court speaks through its orders, and the order itself was very clear. Mr. Welch does not allege that the order was ambiguous. He alleges that he was confused by something that happened in a hearing. Mr. Welch was not held in contempt for violating a ruling or a discussion with the judge. The only allegations that we alleged and the only allegations from which he was held in contempt are counts of contempt, conduct that occurred after an order was entered, after a valid, clear order was entered directing him to do specific things. And again, this is 142 times of contempt. As you see from the record, this is 3 of a longer series of petitions. This is not an individual who is making efforts to comply. And as I said earlier, that is the first place, I think, for the court to start in its examination is, does my client have the burden of proving that he violated the court order? There's no doubt. But before we get to that stage in the examination, we first must look at the fact that there was an order in place. And the entry of the order was the trial court's initial finding that Mr. Welch had the ability to do these things. This is a man of great wealth. He certainly had the ability to pay for these tests. He was able to take them at certain times, just refused to take them at others. And then I think it's important to also look at what efforts he made and what his conduct was to remain in compliance. When an order is entered that compels a person to do a particular thing, it is their obligation to do that thing and to make sure that when they are to test at 9 p.m., that they're testing at 9 p.m. and that they're doing what they need to do to comply with the court order. There's very little point in a court order being entered if a party can just say, well, that was great that the order was entered, but I have no duty on my part to actually comply with it. I'm going to sit back and I'm going to do nothing until someone makes me, and then I'm going to file an appeal, and then I'm going to file an appeal, and then I'm going to file an appeal. I think the law that Mr. Welch is asking this court to take would render every order useless. And when you have an individual who has violated a court order as many times as this individual, I think the 50 days sentence was appropriate, particularly because the court tracked it specifically to the conduct related to the minor children. So we're asking the court to uphold the ruling and a sentence of 50 days to Mr. Welch, 20 days of which was suspended.
Ms. Rogers, which was the exhibit number that you were referencing where the parties got together and agreed or aggregated the counts?
As I'm standing here, I don't know that it was actually made an exhibit to the record. It was an exhibit that we worked on together to give him the totals. The court asked us for the totals simply so he could deal which ones were sober link.
Was that presented as a stipulation, or how was that presented to the court?
We did stipulate to the numbers.
Okay.
The totals were agreed upon.
Oh, I see. Okay.
Based upon the criteria the court had given us, yes.
Okay.
Thank you. I believe you have 3 minutes.
I wanted to address the issue of the minor children. You know, Ms. Rogers talks about that the serious charges were those of the minor children. We talk about the oldest son, Corbin, oldest minor son at that time. He turned 18 shortly thereafter in December. But the point being that the relationship between he and his mother is contentious, to say the least. He testified in one of the hearings about some problems that he was having at the home, and it didn't get any better. To say that Mr. Welch moved that child to his home assumes things that are not in the record. Corbin Welch has testified that he had a hunting cabin that he would stay at quite a bit, that he is a mature child, that it was acknowledged that he was a mature child, and graduated from his high school, Briarcrest, with outstanding grades, and is involved in the family business. They say that since he, quote, moved in with the father, that he was always with the father when the father had alcohol in his system. But yet in testimony, Mrs. Welch did not say that. She could not testify where this young man was at the time of this test that was taken that had alcohol in the system. Now, we argued about that. I could not get her to admit that. She would say things that, he's in school, that's the way he's raised. But the facts are, and the record shows, that she ultimately did have to say that she could not testify where that child was at the time of the finding that Mr. Welch had alcohol in his system, which is the basis of 3 contempt charges. So again, a failure of proof. Was that child physically present? Don't have any answer to that because she could not testify to that. The issue of the sentencing, the guidelines for sentencing give us a whole list of things that we look to determine whether it's a reasonable sentence. And this chancellor gave Mr. Welch the maximum days and the maximum fines for all he's found. No indication, no discussion, no thoughts of a less restrictive means.
Wait a minute. He gave him the maximum?
He gave him 10,000. He gave him 10 days on each one he found, and
10 days
and $50 fine.
142 counts.
I'm sorry.
Didn't he find him guilty of 142?
142. He suspended a lot of time.
Okay.
He suspended a lot of time as let's see if he does better going forward. But there are actually 50 days in jail that he is supposed to do. So he gave him the maximum. We think the record does not support any of the findings of guilt. And you've heard those arguments, and we think the sentencing is excessive. And we really don't know how the court made the analysis because there's a failure for findings of fact and conclusions of law. And it's...
You used your time.
Thank you.
Thank you. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. Thank you for your argument. You're excused.